Hi everyone, Joe Gentile from Sarraf Gentile LLP. So in today's video, we're going to be discussing the relatively recent spike in denials for L-1B visa applications. So for those of you that are unaware, L-1Bs are for intra-company transfers for employees with specialized knowledge. So if you have a company and there's offices overseas and you want to transfer an employee to the US office and they have specialized knowledge, you would typically seek to use an L-1B visa to do that. Recently, we're seeing denial rates as high as 1/3. 1 out of 3 applicants are getting denied for an L-1B visa. And just to give you a point of comparison, H-1B denials are less than 10%, it's around 5%, I think. So L-1B cases are getting denied at a huge clip. When that happens, it's very common that USCIS is going to be making some mistakes when they're denying that many applications. They could be misapplying the law, they could be not considering all the facts or all the evidence that you're putting in front of them. So what happens if you do get a denial for a critical employee, or if you're the employee yourself and you get denied a transfer? You have a few options. Two of the most common options are you could appeal to the AAO, or you could file a lawsuit in federal court seeking to have a judge reverse the denial. The AAO appeals are typically not the way to go, in my opinion. And that's because the AAO affirms denials at a really high clip. So if you appeal a denial to the AAO, over 90% of the time that denial is going to get confirmed. And to make matters worse, they're likely to do it on grounds that are more fulsome than the first denial, which has the effect of making your ability to go to federal court to have a judge overturn it more difficult, because the judge is only allowed to consider what's already been put in the administrative record. So if the initial denial was on weak grounds and you go to federal court right after that denial, then the government is going to have to defend their decision based on the weak denial. But if you go to the AAO and you give them a second bite at the apple, you give them a chance to flesh it out a lot more, it's going to be a lot harder to win in federal court. In most instances, I think you're probably, if there really is a denial that could be considered arbitrary, they didn't consider everything that was put in front of them, they misapplied the law, there's some other grounds that you could oppose them on. But if they really make a real error, probably better off going straight to federal court. A lot of times, if you have a strong case, these cases will settle before it gets to a judge's decision. So one of the reasons for that is because USCIS is not going to be defending this decision. The Department of Justice is. And the Department of Justice typically is not interested in defending something that they're going to lose on. That's indefensible. So if you have a good case, a lot of times it could get resolved pretty quickly. So generally, I think going straight to federal court is always going to be a better option than the AAO. I suppose there's some instances where that's not true, but as a rule of thumb, I think that's pretty accurate. So if you have an L-1B visa that's been denied and you think it just doesn't look right, it's probably worth it to run it by somebody that handles federal immigration litigation. There's probably a chance that you can get that reversed. As always, if you have any questions, please feel free to reach out. I encourage you to subscribe, and thank you for watching the video. Much appreciated. Bye.